All right, we're going to try this again. The Committee on House Regulatory Reform will now come to order. Thank you, Madam Clerk. Will you please call the roll?
Chair Carter,
Present.
Representatives Liberati,
Present.
Neely, here, Scott, present, Young, here, Grant, here, McFall, Snyder,
Here.
Wilson, here, Mueller,
Here.
Filler,
Yes.
Wenzel, Aragona,
Yes.
Beerline,
Here.
Nyer.
Here.
Mr. Chair, if 13 members present, you have a quorum.
Thank you, Madam Clerk. Request approval and adoption of the minutes from the previous meeting. Representative Aragona moves to adopt the minutes from the February 2023 meeting. Seeing no objections, the minutes are adopted. Today, we have House Bills 4886, 4887, 4888, and 4889. Representatives McKinney, Fitzgerald, Aragona, and Mueller, manufactured housing. We're going to take up testimony today, and we will have Representatives Mueller and Fitzgerald. We'll be given an overview of the bills. We're going to stand at ease. The Committee on House Regulatory Reform will now come back to order, and we will have Representatives Fitzgerald and Mueller. Thank you, gentlemen. Whenever you're ready.
Good morning, Chair. Thank you so much for the opportunity to be here today. I'm here to speak about a package of bills that is really going to, I think, modernize a lot of aging laws that we have here in the state of Michigan. Since the 1970s, Michigan's regulatory structure for manufactured housing communities, licensing, inspection, enforcement, and all other aspects of manufactured housing was really the envy of the country and operated very well. The Mobile Home Commission Act and associated administrative rules were put in place to correct two perceived abuses affecting the industry. First was exclusionary zoning and uneconomical or non-uniform construction standards from local governments, and the second was park owner-operator consumer practices such as entrance and exit fees and tying arrangements, or the home sale tied to site rental. The Act remedied these perceived abuses by providing for statewide uniform construction standards, prohibiting exclusionary local ordinances, defining and prohibiting what is, quote, unfair and deceptive trade practices, and providing a single agency for consumer complaint processing and enforcement. The Act also created the Mobile Home Commission within what was then Department of Commerce and now LARA due to its unique regulatory structure and importance of this industry to commerce and housing in the state of Michigan. The Commission was given broad powers to promulgate rules and to establish a uniform policy relating to all phases of, quote, mobile home business. The Commission, however, was not provided with any direct enforcement authority, but was provided with an authority to impose license sanctions and fines to industry participants which were found by the department to be in violation of the Act or promulgated rules. During the 1990s, through a series of executive orders, much of the Commission's authority, including the ability to promulgate rules, was transferred to the director of the now Department of Licensing and Regulatory Affairs. The once dedicated staff of the mobile home division of the department was essentially absorbed into the Bureau of Construction Codes and shared staff for all other building and construction related industries. The erosion of appropriate state regulatory oversight and focus has continued until now. With that, I'll turn it over to my Representative Mueller, another sponsor on the package.
Thank you, Mr. Chair. The bill that I'm running through is Bill 4887, and unfortunately I can attest firsthand one of the very first issues that came to my desk as a newly seated House freshman came from residents of a manufactured housing community in my district. The good news is that these issues can be addressed, and we're trying to address them now. For example, one of my very first office hours in Holly that I'm walking into, imagine your first time doing office hours and you walk in and there's 90 irate people. I'm like, is this really what I want to do? I mean, I literally had to go into cop mode and split people up and do this because, short story on it is somebody came into the area and bought up, some of the manufactured homes in the community. They weren't being run they weren't being run properly. Leases had expired. People weren't updating their leases. And then the new company came in. They did what they had to do to update the park, but they weren't updating the residents. And, some of these people are on limited incomes, they're seniors, and they're installing water meters without, the proper person doing it that's certified to do it. And so it just kind of created a hardship for some of these people in a few of these mobile home parks in my district. But, on top of that, we have a housing supply, we have housing supply and affordability crisis in Michigan. We are asking developers to provide more housing, better housing, and cheaper housing. And as a state, we are pouring hundreds of millions of dollars into these efforts. A balance must be found and struck where strong, effective, consistent, and enforcement of regulations exist to protect manufactured housing community residents without penalizing the hundreds of community owners that are doing it right statewide. Nearly 250,000 Michigan residents live in manufactured housing communities, the vast majority of which are welcoming, well-maintained, and affordable. House Bills 4886 through 4889 will ensure residents of these communities have the homes and communities that everyone deserves, while also ensuring we continue to provide the supply of affordable housing that is necessary to bring us out of this housing crisis we are in today. My bill, specifically the one that I'm doing, amends the Mobile Home Commission Act to add new requirements for written lease agreements to include expanded transparency and protections for residents, such as requiring the written lease include the amount the resident agrees to pay for the rent and incidental services, and whether utilities are included in the rent or a separate payment. And the thing is in my background in law enforcement, you have the opportunity to go to a lot of these places, and there are a lot of them that are run really good. It's affordable housing, and anytime you have a lot of people in close proximity, you're going to have issues. It's just like an apartment complex too, as well. But you did see some that were run, really bad. And so what this does is it's more transparency for the homeowner of the manufactured home, and as long as the owners are doing things correctly, it's more transparency to them and accountability for them. And what it does is it weeds out the bad actors.
My bill, specifically 4889, really it creates a new section 4A of the Truth in Renting Act, requiring that all lease agreements for mobile home and seasonal mobile home parks contain a myriad of different qualifications. Basically saying when does the lease begin. I know that seems pretty rudimentary, but it is required under this bill. Contact information for the mobile park owner, whether you can post a for sale sign on the mobile home so long as it fits park rules. But really, 4889 does help to create that accountability for all parties involved. And lastly, it does amend Section 6 of the Truth in Renting Act regarding violations and proposes all of this under, again, new Section 4A. So with that, we do have industry experts here today to testify in some of the more technical aspects, but we're happy to take questions.
Thank you, gentlemen. I have a quick question. So in House Bill 4886, is there any mechanism to provide compensation to the mobile home owner if the house is taken through the abandoned process?
We do not have that in front of us, but I believe one of our industry experts should be able to answer that for you here later in testimony.
Okay. I think that is a huge question. If it's done through that process and it's valued at a certain level, does that person just lose everything based on that? So hopefully we can get that answer. Representative Filler, you had a question?
Thanks, Reps. Thanks, Chair. So this is a rather broad package. I guess if I had to summarize my own understanding, spells out the rights and responsibilities for the renter and the property owner, and adds transparency for the process of owning a mobile home. Paying attention to all the testimony, so I do appreciate you two bringing this up. But I guess one thing that I worry right off the bat is residents who are having a tough time paying rent or purchasing a mobile home. I assume there's programs or processes to help those residents. Do you guys speak to that, or will someone speak to that later? Written into this package? Thank you.
I think you'll hear that later in testimony. I think that the point here that I think Rep. Mueller really brought up, which is, we're looking at really addressing the housing crisis, and this can be a component of that. And yes, we want to make sure that people have access to capital, that their rights are respected, that we have the ability to, yes, pay a mortgage or a bank note or a lease or a rent on any property, and that this is going to be a component of that. And so we'll make sure that is highlighted here later in testimony to really speak to what that looks like for individuals.
Thanks, Rep.
Thank you. Representative Wilson.
Thank you, Mr. Chair. Just a quick question. I know that you all most likely worked with industry experts on this package. Did you work at all with the administration or any state departments that will be enforcing a lot of items in this package?
So we've had commentary ongoing with various departments. I think that the key here is that we want to, yes, look at what, who is, if you will, at the table, in the trenches, dealing with this when a lease is negotiated, what happens when there is a property dispute on site. So we have been working with industry experts, but of course you're going to deal with state departments who are working with licensure and regulatory agreements that they're going to bear some of the brunt here when there are issues. They're going to be remaining as stakeholders and significant voices in this process.
Thank you.
Thank you, gentlemen. Next, we'll hear testimony from John Lindley, Marge Burns, and Bruce Thielen from the Michigan Manufactured Housing Association. I do have quite a few cards, and I want to make sure that everybody gets the opportunity to be heard. So be as brief and concise as possible, and make sure you get your points. Thank you.
Good morning, Mr. Chairman, members of the House Regulatory Reform Committee. Thank you for the opportunity to testify today. My name is John Lindley. I'm President and CEO of the Michigan Manufactured Housing Association. And again, we appreciate the opportunity to be here, express our support of House Bills 4886 through 4889. The association's roughly 650 members represent all segments of the manufactured housing industry: home builders, suppliers, retail sellers, lenders, installers, community owners, community operators, and others who serve the industry. Michigan is a leader in the manufactured housing industry, ranking in the top 10 in shipments of housing each year, with more than 12,000 new homes delivered to the state since January of 2021 alone. The state is home to nearly 1,100 manufactured housing communities, with nearly 250,000 Michiganders living in manufactured homes. With me today are a couple of association members and industry leaders, both here in Michigan and nationally. First is Marge Burns, owner and president of Germano Management, a family-owned second-generation Michigan small business owner with approximately 800 home sites and 2 beautiful manufactured housing communities. Marge served as the Michigan Mobile Home Commission for many years, including service as chair of the commission. Second is Bruce Thielen, chief operating officer of Sun Communities. Sun Communities is a proud Michigan-based company and the nation's largest manufactured housing provider, with nearly 32,000 home sites in the state of Michigan. There's no question that Michigan has a housing affordability and supply crisis. Home ownership opportunities are a significant factor in addressing these needs, and manufactured housing makes the dream of home ownership attainable for millions. This package of bills accomplishes several key goals to open the door to not only increase the number of homes available, but also to improve the quality of manufactured housing communities in the state. Michigan Manufactured Housing Association members provide housing to hundreds of thousands of Michigan residents in welcoming, safe, and affordable manufactured housing communities throughout the state. Unfortunately, like many other industries, a small minority may not reach that same standard of excellence. We believe there's room for reform within the industry, and House Bills 4886 through 4889 will provide the strong regulatory and enforcement structure needed to protect residents, while also encouraging ongoing community development and improvement by good operators.
As John said, I am Marge Burns. I'm a member of the Michigan Manufactured Housing Association Board of Directors, and my family has been in manufactured housing industry since 1979. And as was mentioned, I previously served on the Mobile Home Commission. As an industry veteran and from a regulatory perspective, I can tell you that nearly 100% of community quality issues could be resolved by the State of Michigan agency charged with oversight of the industry adequately enforcing existing statute and administrative rules. For example, Section 16 of the current act provides that a person cannot operate a park without a license. Section 36 authorizes the department to investigate violations of the act. Section 41 authorizes the department to get an injunction against someone violating the act. And Section 43 allows the department to impose a fine of up to $50,000 for violating the act. Further, many existing administrative rules contain key direction regarding inspections and enforcement, as well as establishing a complaint process for residents with concerns about their community. To ensure the state has the tools and resources necessary to fulfill its vital role, this package focuses on reinvigorating the state's focus and regulating manufactured housing communities by increasing licensing fees and earmarking the fees to matters associated with the industry, supporting residents. It establishes a hardship fund to use for residents and community owners needing assistance during transitional times, for example, eviction, home relocation, emergency infrastructure improvements. Significantly increases penalties associated with operating an unlicensed community. Requires licensee notification to LARA of any changes in ownership address. Reauthorizes existing administrative rules I described previously. Compels LARA to ensure commission meeting frequency and requires LARA to allocate appropriate staff resources to the industry, and requires LARA to create and publish a public-facing database of all communities, including license status and contact information. It is crucial that the laws and rules regulating the industry are appropriately enforced, something we would argue has not been the case for a number of years.
Thank you, Marge. As John said, I'm Bruce Thalen, the Chief Operating Officer of Sun Communities. We own and operate around 80 manufactured housing communities in Michigan, providing welcoming, well-maintained, safe, and attainable community living for tens of thousands of Michiganders. Further, while our footprint is nationwide, we are proud to call Michigan our home, where we provide hundreds of jobs. As community owners and operators, a strong relationship with our residents is critical in delivering a vibrant and healthy community. I echo Marge's commentary on the regulatory structure in Michigan and would like to address another couple of important matters contemplated by this package. First are the proposed benefits to manufactured housing community residents through providing increased lease protections. The lease agreement between a community owner-operator and the resident is an imperative document that provides critical protections to residents. This package proposes to expand and clarify resident protections and increase transparency included within a lease, such as the amount the resident agrees to pay for rent and incidental services, and whether utilities are included in rent or a separate payment. The requirement for a 5-day grace period on rent before commencing delinquency proceedings, and a provision requiring the offer of a new lease at the end of the term unless the owner has good cause not to. This package proposes to codify these lease requirements in both the Mobile Home Commission Act and the Truth in Renting Act. Secondly, I would like to focus on the problem of abandoned manufactured homes in Michigan. Abandoned homes in communities diminish curb appeal and suppress home values. They can also lead to safety issues for residents and team members alike. Further, the lack of an efficient process for the removal and replacement or rehabilitation of those homes exasperates the current housing supply crisis. It is important to take a couple of minutes to ensure everyone is aware of just what we are talking about when we say abandoned home in a community. This situation arises when a resident chooses to leave behind their home to live somewhere else without providing proper notification to the community owner. Abandoning the home is the easiest decision for the resident, leaving it behind and making it the community's responsibility to remove the home or fix it up for a new resident. In most instances, we will put a brand new home on the site, increasing the value of everyone's home in the community in the process. In February of 2020, the Michigan Secretary of State eliminated a process that had worked for decades, by which the owner of a manufactured housing community could secure title to an abandoned home. In the absence of this process, it now takes multiple court appearances and a minimum of a year of delays before securing a title. Frankly, when manufactured housing community residents justifiably complain about abandoned homes in their community, or when Michigan citizens in general justifiably complain about the lack of attainable homeownership options, this is the perfect example of why those problems exist. This legislation creates a streamlined process for community owners to identify abandoned homes, provide notice to the resident who abandoned that home, then apply to the Secretary of State to obtain a new title. This package proposes to implement a new process in statute which provides significant due process and protections for homeowners while allowing for efficient title acquisition by community owners when appropriate. Solving this problem is quite literally a win for everyone involved. Governor Whitmer has said blight elimination is vital for the well-being and future success of Michigan. Removing and rehabilitating blighted properties creates a ripple effect of positive change that not only reclaims neglected spaces, but fosters economic growth, enhances safety, and bolsters community pride. When the governor speaks of rehabilitating existing home stock, this is a perfect example. When she speaks of new homes, this is a perfect example. When people speak of removing blight, this is a perfect example. Eliminating the current lack of process and unnecessary year-plus delay to secure a title translates to hundreds of new attainable homeownership opportunities for Michiganders.
As we've said, the Michigan Manufactured Housing Association members provide housing to hundreds of thousands of Michigan residents in clean, welcoming, safe, and affordable communities throughout our state. To drive forward toward our shared overlapping goals of addressing quality, affordability, and increasing the available housing supply, we should consider reforming zoning restrictions to help our state grow, increase home ownership equity across race, ethnic, and socioeconomic groups, and increase home ownership among low and middle income households. That's how we build a state where everyone can afford to live and thrive. Now more than ever, Michigan needs affordable housing to help people fulfill the dream of attainable home ownership. The manufactured housing industry is deeply committed to turning that dream into a reality. We'll collectively try to answer any questions that you may have. Mr. Chair, with your indulgence, I'd address a couple of questions that I know came up during the previous testimony. Just to start with, number one, we have had communication relative to this language with the Department of Lara and the Secretary of State's office. I can't speak to their position on the matters, but we have been in communication with both of them. And relative to the process in 4886 on obtaining the abandoned title for that, language associated with the value of the home and remitting that to the resident is something we absolutely would be willing to look at. It's important everybody understands that in nearly 100% of these instances, what we're talking about is somebody who has abandoned what was once their home with associated, several months of late rent due, other fees, et cetera, and doesn't want to be communicated with. Finding that individual and being able to communicate with them is generally something that just results in months and months and months of spinning wheels in an attempt to get a hold of them. They don't want to be communicated with. And so trying to secure that communication is where the struggle often is and where the delays often lie.
I have a quick question. During your testimony, you spoke that the rules changed in 2020. What were they previously when it came to abandoning or applying for?
Can you answer?
Previously, the community would have a bond, an insurance bond, and if the home had been abandoned for 60 or 90 days, we would be able to go to the Secretary of State and get a new title in our name. And if that previous homeowner came in, that bond would cover their costs, so they would get reimbursed. But in general, that pretty much for our communities never happened.
Thank you. We have a question from Representative Grant.
Thank you, and thank you all for being here today. Marge, I have a question for you. I know you mentioned that you currently own 2 communities, is that correct? And since we're talking about value of homes, do you have an idea of what current value in one of your communities would be now for a home? Like if there was a home for sale today, what the average value would be or sale price?
Thank you, Representative Grant. I appreciate the question. Yes, I do. I actually have what we call pre-loved homes that we go in and completely refurbish. Typical 3-bedroom, 2-bath ranges from $45,500 for about 1,000 square feet. We have one that has a garage and many other attributes, porches and things like that. That's about $125,000. For a new home, we have a single section home that is a 1,000 square feet for $72,000. And a new home, which is 1,500 square feet, again, 3-bedroom, 2-bath for $131,000. So as you can see, they're quite attainable and affordable, and we do work with finance companies to help residents and potential prospects get loans.
Thank you.
Representative Mueller.
Thank you. Just a quick question for the owners. what is the time frame for, like, if you know someone has abandoned their home, but you know you really can't? Can you enter the home after 30 days? Because the problem is you know what I saw when I was working on the road is you know when someone abandoned some of these homes in some of the more lower rent income places where I had worked. What kind of, I mean, I can tell you, but in your experience, I want you to tell some of the people on the committee, what kind of things are you finding in those homes? And, you know, they're abandoned, so people leave food, they leave dirty diapers, they leave animals inside their house and all that, you know, so there's a lot of blight and the bed bugs and cockroaches and all that type of stuff that the people that are living around them don't need to deal with because somebody doesn't want to pay their rent. That you should be able to go in and be able to at least clean that out. Is there anything that we can do about, you know, maybe speeding up that process with this too? Because, you know, for instance, one of the mobile home parks, I won't say where because I don't want to put, you know, they actually had to remove the whole single wide trailer because when I walked into it, the walls were crawling with cockroaches. So they had to take it and burn it.
Thank you, Representative Mueller. I think our experience is similar to sort of what you laid out. I mean, the time frame for us now can take over a year to get an abandoned home removed. And again, to reiterate what I mentioned in my testimony, the primary issue is the inability to make contact with the owner of the home. When a home is abandoned, you know, the resident typically understands that the value of that home has dramatically diminished. So the types of homes that we would get back on an abandonment would be a home similar to what you are describing that has a lot of issues, that has not been maintained well, in a lot of cases has had a lot of trash left behind, potentially pet damage to the home. It runs the gamut, but it's important to keep in mind that the homes that are coming back are the homes that the resident recognizes there's little value, and in many cases they ultimately need to be removed and replaced with a new home, which is a huge win for the folks in the community. The residents in the community, when we're able to take a home that's dilapidated and has major structural issues, we're able to remove that home and replace it with a new one, thus enhancing the value of the community and ultimately helping to bring up the equity values of all of the residents that own in the community.
I'd like to address this as well because we currently have several homes that are not titled in our communities, and it takes well over a year to get that title, as you have to go through several court appearances and then, you know, get a judgment, and then from the judgment go to the Secretary of State, and then you've got to wait for them to issue the title. And I have been in several homes, as you described, Representative Mueller, that there are just piles of clothes and furniture, food left everywhere. I have unfortunately seen a gerbil in its cage, and we can't go in, and I've seen a cat under piles of clothes, and we can't go in to that until we have a title. And so for all of the residents, it's becoming a safety issue because other people find their ways in sometimes and do things that are not necessarily legal in those homes, and yet we can't go in because it's not our home. And so it presents a problem for all residents in the communities.
Just a quick follow-up. Is there anything in statute currently, because of the eviction process, but how do you evict someone that's voluntarily moved? Is that where the hang-up is? Because if you can evict someone, at least you could go in there and take their property out so you can get rid of all that stuff, or have the sheriff come in and do it, you know, civilly, versus like when somebody just abandons it. But is there any way to eviction if it's been abandoned?
Ask the community owners to correct me if I'm wrong here, but my understanding, the current process or lack of process that exists, the eviction process has to take place and be completed prior to starting the process of seeking the title. So those two processes aren't happening at the same time. They're happening back to back. So you have to go through the entire eviction process, which again, because of court delays and everything else, can take upwards of a year prior to even starting the process of obtaining the title for the home.
Seeing no further questions, thank you for your testimony. I find it interesting, 2020, during the pandemic, a lot of rules changed concerning landlord-tenant relationships. With that, wishing to speak in opposition of the bill, we have 4 people. We have cards here for Deb Campbell. Ms. Campbell, come on up. Push the red button so that we can hear you.
Okay, can you hear me now? Okay, thank you, everyone. Thank you for the opportunity to be here this morning, too, and to be heard. I'm Deb Campbell, and I've lived in Sherwood Forest, a 55-plus community in Ionia for almost 2 years. I own my home, but I rent the lot underneath. And as you may know, renters like us, or owners like us, we're kind of a special category because we're a hybrid between a traditional renter and a traditional homeowner. As a lot renter, I'm responsible not just to maintain my house and keep it all up, I'm also responsible for the maintenance of my lot, the sidewalks, the driveways, the trees, the bushes, all of that. And many of our residents also pay property taxes on their sheds, on their garages, on any leasehold improvement that they've made. They receive a bill from the local taxing authority and they pay property taxes at the homestead rate. So many of us are also property tax payers. Since I've lived in Sherwood Forest for almost 2 years now, my total rent increase has been 22%. That's almost double my Social Security COLA. And at that rate, if it keeps on going, it's not going to be long before I'm priced out. Frankly, I never imagined living in a manufactured home community. But after my husband died and I retired, I knew I had to find something that I could afford on just my income. After an exhausting search, and I mean I looked for a good 5 years, and I found nothing affordable. I went and looked at a brand new double wide offered for sale by Sherwood Forest. It was beautiful, 1,800 square feet, 3 bedrooms, 2 baths, drywalled, upgrades. It was everything that I was looking for. And at about 55% of the cost of what I would have had to pay for a similar new stick-built home, it was affordable. For me to move my home and all the improvements would cost upwards of $20,000. Zoning restrictions and the high cost of lot rent in the other communities in my county, and we have 17 communities in Ionia County, but they all have the high cost, equal to, some are even more than what I pay for lot rent. So it makes me moving impossible in all reality. In my county, only 3% of the home sites are controlled by local mom and pop owners. So there is no competition, therefore there's no competitive pricing. I'm trapped. I am a hostage in my own home. But what really keeps me up at night is the package of bills that we're here for today, especially 4886. Under 4886, as it reads, my home can be deemed abandoned if I'm 30 days late with rent, or I disconnect utility services for 30 days, or it appears that my house has been vacant for 30 days. It also provides that I can notify the owner that I'm intending to leave. But technically, under this bill, I don't even have to be late to be declared abandoned. What if I went to the hospital for a couple of months? What happens when I die? With this bill, I have no right to a court hearing or due process. Once they start the abandonment, there's no option for me to catch up my arrears or try to sell my house. The only option I will have is to move it. And when it isn't moved in 30 days, they get my title in another 30 days, all liens are extinguished, and I lose my entire investment. The Supreme Court in Michigan ruled in 2020 that surplus funds from properties seized at tax sale must be returned to the owner. Foreclosed properties sold at sheriff's sale return excess funds to the owner. Even owners of repossessed cars are entitled to surplus funds. As a former banker, I can tell you that nobody ever lost a house to the bank or the government after being just 30 days past due or not living there 30 days. But if this bill passes, hundreds of thousands of us can have our homes seized and nothing to show for it. Right now, there are people losing their homes without compensation. And this bill would increase the incentive and make a bad situation even worse. You can't imagine the sleepless nights I've had worrying about this. Why is it that there are laws to protect fee simple owners, but it's okay for our seniors, our veterans, disabled, people living on lower fixed income to live without similar safeguards? Living in a manufactured home community should not make us less worthy of the protections given to traditional homeowners. The thought of being priced out, losing my home, my community, and my wonderful neighbors is taking a toll on my health. And my neighbors are also worried sick about all of this. When they read 4886, they're shocked and horrified. I respectfully request that you oppose House Bills 4886 through 4889, especially the provisions in 4886, which, as written today, to me, are un-American. I urge you to support the fundamental protections in House Bills 5157 through 5163, which will offer modest but real protections for us. Thank you for letting me have a voice today.
Thank you, Ms. Campbell. Any questions? Next, wishing to speak in opposition, we have Holly Hook.
All right, thank you, Mr. Chairman. My name is Holly Hook, and I live in Swartz Creek Estates in Swartz Creek, Michigan, which is also a manufactured home community. Before 2018, we had a great community owner who charged very reasonable lot rent and kept the community running, well-staffed, and looking beautiful. Unfortunately, we were sold in 2018 to Haven Park Capital, an out-of-state owner, and immediately our rent went up 25% in 1 month. And we were given no way to reach or contact the new owner about anything. Over the next few years, Haven Park kept increasing the rent and adding fees, and they cut down our staffing at the same time so that the same manager was managing multiple parks instead of just one, so service went way down, and we had no idea where our rent increases were going because we had no amenities added or anything like that. And my community is one of the luckier ones. Many residents around Michigan are suffering from severe cuts in maintenance, which cause health and safety issues. People are tripping and getting hurt. Many communities have sewage backing up in places and forming puddles. And the water from the taps in some communities is yellow or orange. This is tap water that another resident brought to me today. I don't want to open this. It's scary. Many community owners fail to address these issues, and residents are stuck circling between LARA, law enforcement, the attorney general, and they keep getting bounced back and forth and going in circles because there's no means to enforce anything. And meanwhile, predatory owners are not facing any consequences for these horrible living conditions. And these predatory owners, they often lose rent payments, intimidate, they're fast to evict, they shut off water randomly, and there's no transparency for utilities in many communities, so we have no way of knowing if what we're paying is what we should be paying. This is happening to seniors, veterans, disabled folks, and hardworking families. Even worse, LARA is currently unable to enforce our current protections written in 1987, and this leaves residents with no recourse. And because we're a very unique class of renters, as we also own our homes, we can't simply pick up and leave if we fall behind on rent or anything, and this leads to many people simply having to abandon or lose their homes without any compensation. I'm testifying in opposition to House Bills 4886 through 4889. These bills provide little to no protections for residents, and they provide very few consequences for predatory owners who engage in these unsafe practices. These bills don't address any rent transparency. We have no way of knowing if our rent increases are actually fair. They don't address utility transparency that are really hurting seniors. They don't address ease of payment for seniors because in many communities they're forcing electronic payments, and many seniors don't know how to do that or don't have a computer. They don't address sewage backing up into the roads or anything. They don't address this horribly colored water here that I still don't want to open. And they don't address serious infrastructure issues. And these bills don't impose many consequences or enforcement for failing to offer a lease or contact information for the community owner. I'm here today with other grassroots leaders from Holland, Kalamazoo, Battle Creek, Rochester Hills, White Lake, Clarkston, Auburn Hills, and Northville. It's not a small thing for folks of modest means to drop everything and go to Lansing for a day, let alone 2 weeks in a row. And there would have been more of us if we'd had a little more notice. Last week, 750 Michiganders submitted cards to the Senate Housing Committee in support of the real protections offered in Senate Bill 486 through 492 and the companion House Bills 5157 through 5163, which I believe are assigned to this committee. I urge you to support the real bills that provide protections for real people in our state who are suffering from these terrible living conditions and at the hands of predatory real estate speculators. I urge you to oppose the distraction and especially the incentives towards home theft in 4886 through 4889. I thank you for your time and for listening.
Thank you for your testimony. We do have a question. Representative Filler.
I feel like we just have a question or an issue that we have to deal with, this water that you brought. Is that Eagle? Is that Laura? Is that, I mean, what?
We don't know.
Something's gone wrong here.
Yeah, people have tried contacting Laura. They say talk to your township. They try talking to the township. They say talk to Eagle.
Is this a private water system? Is it muni? I mean, where did it come? I feel like we have to.
I believe they said this was city water.
Okay, and the city has to work with Laura to get licensure under our laws. So something's gone wrong.
Something's gone wrong.
All right.
Yeah.
Well, we got to fix that, don't we?
Thank you. Next, we have wishing to speak in opposition of the bill. We have Angela. Trying to read your last name, Angela, from City Council President from the City of Warren. Okay.
Hello, my name is Angela Rogansey. I am City Council President in Warren, Michigan, and a current at-large City Council member. Thank you very much for your time today and the opportunity to testify. I am here in support of regulation of mobile home parks, but not specifically the bills that you have brought forward. I am in support of the mirror bills that you have that are currently in the Senate which many of us will be testifying later. Warren has over a dozen mobile home parks. We are the third largest city in Michigan. And we are very grateful for the diverse housing stock that we do have. There are many folks of diverse economic means in Warren, and we're grateful to have mobile home parks. However, many of them are in tremendous need for repair. I provided you a presentation that I presented to our city council in the summer of 2022 when I was asked to get involved in a situation with one of our parks, Landmark Estates, which the company owns a couple of parks in Warren, as the living conditions were deplorable and our city attorney and building department were struggling to move the ownership group to action. I've been fighting for residents in manufactured housing for now over 2 years. Our City Council, unfortunately, has very little jurisdiction over the conditions of mobile home parks. The only legal action we were able to take as a legislative body was to file a public nuisance complaint, which we did twice against the ownership group to try to get them to comply. Unfortunately, the pictures in that packet are still very much true. Beyond some removal of some blighted trailers and trailers that were certainly health and safety standards, there has not been much changed in the park over 2 years. After seeing the conditions that residents were living in as they did tours of their mobile homes, I was appalled. Residents showed me where they stuffed clothes and holes in their trailers to keep rats from further eating through their trailers. A family of 5 slept in one room because rats came in at night and they had boarded up and figured out a way of attempting to keep rats out of the one bedroom in which the family of 5 lived. They showed me trees growing up through their trailers, trip hazards, running water all over the place, sewage, and abandoned trailers with garbage piled up in them so high that you could see it through the windows. I phoned our Public Works Department, Laura, Eagle, and the Attorney General trying to determine who had jurisdiction over mobile home parks. Much to my surprise, much of the industry is unregulated, or as many folks have communicated, is incredibly confusing to sort through. As a locally elected leader, I can hold renters accountable through our rental ordinance. Renters and even owners of mobile home parks who rent their lots do not fall into any category I can regulate or enforce. Our only recourse as a local legislative body was to declare the park a public nuisance. The ownership group fear-mongered residents on the edge of homelessness by telling them that I and fellow council members were trying to shut down the park, and went door-to-door to distribute a flyer telling them such and encouraging them to call me and my colleagues. I received dozens of calls from distressed residents concerned about being homeless, which was not what we were intending to do. They threatened our local Macomb Daily reporter who reported on them that if they reported further on them, they were going to take them to court. They have filed PPOs against residents who live there for trying to organize and require better living standards. Residents are without titles or purchase agreements in their units, unsure if they are renting on a land contract or owners of their trailers. They are stuck in their units without the ability to sell them, move out, or otherwise change their housing situation when the park conditions threaten their health. I've spent over 20 years in human services as a profession, including homeless services, Section 8 housing, community mental health, substance abuse treatment, corrections education, transition services, anti-human trafficking for young girls and sex work, workforce development for low-income folks with barriers to employment and low-income education. And all my years of this work in multiple states and cities, these are some of the worst living conditions I have ever witnessed. It also impacts the neighboring communities because they then are impacted by the other homeowners who have homes or apartment buildings that we do regulate, have the ability to, or don't have the ability to have better living conditions, and it impacts the property values of the neighboring communities. And we also have complaints of rats and other things coming from the mobile home parks into other homes. If you look at the company who owns the park, Open Door Capital, you will see that they are a venture capital firm. If you look at the timing of their purchase of parks in Warren and the fund in which they raised capital to do so, you will see they promised their investors 12 to 20% returns. Those kinds of returns on the backs of incredibly low-income families, disabled folks, seniors living next to homelessness, and some of the most vulnerable folks in our society. I am a capitalist. I'm a small business owner and fully believe in people making an honest dollar. However, they are really, really bad actors engaging in predatory behavior with little to no consequences. There are little protections in the bills you have taken up in committee. And I won't address all of them. I do have a side-by-side that I'm happy to share, but I will comment on a number of things that folks have talked about. They talked about a year's worth of time spent on blighting trailers. We have a very good public nuisance program in our municipalities that easily could be adopted if they fit into a traditional housing ordinance or allowed us locally to address public nuisance. That becomes before city council. We declare a building or a home a public nuisance. The balance of the taxes and or cost of that demolition goes onto the tax rolls. It's a very efficient process within the city that can easily be adopted or modified for mobile homes. I heard someone from the industry talk about a small minority of bad operators. You can drive through any park in Warren and you will not see that this is a small minority of bad actors. Every single park in Warren is in need of desperate repair, and this is consistent what I've heard over 2 years working across the state on this issue. There are far more bad actors than good actors, in my experience. The water issue, Rep. Filler, unfortunately, the city of Warren, for example, tests water up to the hookup. Once the water goes into the park, we can do nothing. And so it is private property, and because they rent the lots and then they go into the trailers, we unfortunately locally don't have any jurisdiction. I don't know whether that's Eagle or Lara who would then be the person who tested the water beyond that, but at the local level, I can't do anything beyond the hookup at their building. Additionally, about the abandoned trailers, much of what they communicated was true. I have a gentleman who lives in one of our parks who has a mental illness and was hospitalized for 30 days. And of course, the ownership group would not be able to get a hold of him. He has a serious mental illness and was institutionalized and then came back to then obviously bring his property back up to payment and or let go of his trailer, whatever it might be. But the reality is you wouldn't be able to get a hold of him, and he was institutionalized for more than 30 days. And so the reality that an ownership group can take and seize a property in 30 days is just not fair and in not understanding the community in which they operate in. As in closing, as a legislator myself, there are battles we must pick, as you all I'm sure are aware, and hills we must die on. Regulating mobile homes is a hill I will die on. These are folks in my community that are desperately seeking help, and I am so unbelievably frustrated that I can do nothing to help them. So thank you so much for your time.
Thank you for your testimony and your advocacy. Next, we have wishing to speak in opposition, Pam Maxey.
Thank you, representatives, and bear with me, I'm excruciatingly full up of anxiety here. But I just really want to share my story and how the current regulations are working out for my family and my community, and what the new bills we're talking about here are not going to address. My name again is Pam Maxey. I live at Hillcrest Acres. It's a manufactured home community in Kalamazoo. Hillcrest Acres is owned by RHP Properties, a private equity firm that owns over 50 manufactured home communities in Michigan alone, and is one of the biggest private equity owners of manufactured housing communities in the country. I've lived here with my family for 8 years in a community of 150 home sites, approximately half of which sit vacant. Over the 8 years, our rent has increased every year while the living conditions decrease. Over recent years, more and more streetlights throughout the park have quit working. I asked management many times to replace them, to no avail. I had given up asking until December of 2023. On the morning of December 14th, when all the children were working to the school bus stop in the pitch dark, a drug dealer was carjacked at gunpoint just paces away from my home. The police told me that the people involved didn't live in our community, but drove here because it was, and I quote, so dark and isolated. I asked for streetlights one more time after that, and to this day, we still don't have them. In 2018, my neighbor's home burned down. Everyone was all right, but the home was a total loss, and 5 years later, it still had not been removed. In March of 2023, I filed a complaint with the township, asking them to force RHP Properties to move it. RHP did remove it, but they retaliated by issuing a long series of arbitrary lease violations against my family and all of my neighbors. This is common practice with RHP. The day after we passed out flyers last week, they came through issuing lease violations for such things as a ladder being stored outside or a planter on somebody's porch that doesn't have a plant in it. Residents are harassed to the point of eviction, while at the same time, RHP Properties does nothing about the upwards of 30 blighted homes in our community that present numerous health, safety, and building code violations. In 2023, June, a close-by neighbor informed me there was sewage coming up into his home from his bathroom sink, his tub, and his toilet. He had informed park management, and they told him that even though it was coming up from the ground, it was up to him to fix it. In the meantime, it was left to bubble out of a pipe onto the ground. And then the next month, I was walking my dog, and I discovered a sewer leak that was one street behind me. It was bubbling up out of a pipe that was sticking up in a vacant lot, and it was running down into the neighbor's yard. So we've had numerous sewer backups over the years, and now we have serious questions about the quality of our water. And when I reported this to the Kalamazoo County Health Department in July of 2023, I learned that no government agency can come into our community and test our water. The health department told me to call the Department of Environment, Great Lakes and Energy, the EGLE. The EGLE explained to me that yes, they do oversee all community water supplies in Michigan, but Hillcrest has its own water supply system and is excluded from the way the state defines a community water supply. Hillcrest is what is called customer site piping. This means that the community owner is responsible for assuring safe, potable water is getting to the residents and that they are abiding by the Safe Drinking Water Act. The sad fact is our community owner just doesn't care. All of the people I talked to at EGLE and our health department, they were very sympathetic and helpful, but their hands, they are actually tied. We have extremely low water pressure throughout the park, countless water leaks above and under the ground. We experience discolored water often, as you saw here. It smells bad, ruins our appliances, it ruins our plumbing. People report getting sick from drinking it, so pretty much most of us, we just don't drink it. We pay for water that we can't drink, and then we have to go out and buy more water. And when I ask my neighbors, why do they not complain more, the common response I hear is because we have nowhere else to go. Their fear is real. My fear is real too. I fully expect to face retaliation and harassment for giving this testimony and talking to the media, but I cannot stand by while my neighbors, many of whom are seniors and people with disabilities, get treated this way. I cannot be quiet while this is happening to good people all over the state. In fact, currently there is a class action suit in a mobile home park in Battle Creek that is going through very similar issues as my park. If you won't stand up for me, I hope you will stand up for them. House Bills 4886 through 4889, they would do nothing to protect us. And in fact, it would make it easier for unscrupulous companies to steal our homes. House Bills 4886 through 4889 would make, I strongly oppose these House bills, and I urge you to do the same. And I thank you for listening to me.
Thank you for your testimony.
Yes.
Questions? Thank you. With that, we have 149 not wishing to speak in opposition, and they'll go on the record for these bills. I'll say this. Having this job, you have to know a lot about a little. I want to thank you all for the educational experience today on both sides. Sounds like there's some work that needs to be done, and we'll figure it out. Because I'll be honest with you, I had no idea. And I'll be honest, everybody's not going to tell you that, but I had no idea. So with that, we're going to look at Senate Bill 328, Senator Hertel's 10-year battery smoke detectors. We took testimony last week. Are there any questions from committee members? Representative Bierland.
Thank you, Mr. Chair. Were we able to ever find an answer to the, if we stop the sale in Michigan, we'll stop the internet sale as well?
We did not get an answer to that.
Okay, thank you.
Okay. So with that, I will take a motion to report Senate Bill 328 with recommendation. Representative Mueller makes the motion. Madam Clerk, will you please call the vote?
Chair Carter?
Yes.
Representatives Liberati?
Pass.
Neely?
Yes.
Scott?
Yes.
Young?
Yes.
Grant?
Yes.
McFall?
Yes.
Snyder?
Yes.
Wilson?
Yes.
Mueller?
Yes.
Filler?
Pass.
Wenzel?
No.
Aragona?
Pass.
Beerline?
Yes.
Nair.
Yeah.
Mr. Chair, I have 10 yeas, 1 nay, 4 passes. Senate Bill 328 is reported with recommendation.
Thank you, Madam Clerk. With there being no further business before the House Regulatory Reform Committee, we stand adjourned.